Companies Doctrine provides that a non-signatory can be bound by or rely on an arbitration agreement if the non-signatory is part of the same group of companies as that of the signatory. The Group of Companies Doctrine was first recognized by the Hon'ble Supreme Court of India in 2012 in its landmark judgment of Chlorocontrols India Pvt Ltd versus Servant Trent Water Purification Incorporation. It was held that under certain circumstances, a non-signatory affiliate of the signatory may be said to be claiming through or under the rights of the signatory, and therefore the non-signatory may be bound by the terms of the arbitration agreement signed by the signatory. Some of the key considerations before applying the said doctrine was laid down by the Hon'ble Supreme Court. A. Clear language of the contract. B. The intention of the parties to refer all the disputes between all parties to arbitration. C. A direct relationship between the non-signatory and the signatory. Following the judgment of Chlorocontrols, various courts in India, including the Hon'ble Supreme Court, have relied upon the Group of Companies Doctrine to bind non-signatories to an arbitration agreement in numerous other cases. However, in and around 2022, the Hon'ble Supreme Court in the case of Oil and Natural Gas Corporation Limited versus Discovery Enterprises Pvt Ltd identified key factors which required consideration before applying the Group of Companies Doctrine under Indian arbitration jurisprudence. The factors laid down are as follows. A. Mutual intent of parties. B. Relationship of non-signatory with that of the signatory. C. Commonality of the subject matter. D. Composite nature of the transaction. And E, which is the most important, performance of the contract. Thereafter, the Hon'ble Supreme Court referred these questions relating to the continued application of Group of Companies Doctrine to a larger bench, and the Hon'ble Supreme Court in the case of Cox and Kings versus SAP India Pvt Ltd upheld the continued application of Group of Companies Doctrine in India, though disagreeing with the reasoning in Chlorocontrols and agreeing with the reasoning given in ONGC case. I will be discussing the Cox and Kings judgment and its key takeaways in the following questions. The Cox and Kings judgment affirmed the conditions laid down in ONGC judgment and held that in order to apply the Group of Companies Doctrine in a particular case, not only do the signatory and the non-signatory have to be part of the same corporate group, but they also have to comply with the following conditions. A. There must be a mutual intention or agreement of the parties to bind the non-signatory to an arbitration agreement. That is, there must be an implied or tacit involvement of the non-signatory in the performance of the contract containing the arbitration agreement. B. The relationship between the non-signatory and the signatory must be such that it establishes a tight group structure with strong organizational and financial link so as to constitute a single economic unit or a single economic reality. C. The actions of the non-signatory ought to be connected to the signatory's contractual obligations as enshrined in the arbitration agreement. D. In a composite transaction involving multiple agreements, the court must assess the degree to which various agreements involved are interlinked. As an illustration, if the principal agreement containing the arbitration clause is not capable of being performed in isolation, that is, without requiring the performance of a connected agreement to which the non-signatory is a party, the court may consider it as an indication that the non-signatory intended to be bound by the arbitration agreement. E. The non-signatory has played a significant role in the execution, performance, and termination of the arbitration agreement. Having said the above, it is imperative to understand that the above factors, when considered independently, cannot be the sole basis for invoking the Group of Companies Doctrine. The Hon'ble Supreme Court has tried to redefine the contours of Group of Companies Doctrine to permit its application only after the intent of all the parties to bind themselves to the arbitration agreement is established. courts in India have tried to strike a balance between the applicability of group of companies doctrine with the concept of a separate legal entity by adopting a fact-specific and intention-based approach which emphasizes on the principles of fairness by carefully evaluating the direct involvement and participation of non-signatory in a multi-party contractual transaction. This nuanced approach facilitates justice being served while adhering to the fundamental principles of corporate law. The doctrine has been applied very liberally and expansively, which could make it difficult for non-signatory group companies to escape its applicability. Ascertaining the degree of non-signatories' involvement in the performance of the contract containing the arbitration agreement. Establishing the intent of parties to bind the non-signatory to the arbitration agreement before the arbitral tribunal. Uncertainty for non-signatories to an arbitration agreement entered into by its affiliate. Tracing the economic reality and substantive connection between the signatories and the non-signatories to ascertain whether the non-signatory is part of the single economic unit or the single economic reality with the signatory. Parties may adopt strategic behavior to exploit or avoid applicability of the said doctrine. After the Cox and Kings judgment, there are some of the key points which needs to be kept in mind while negotiating an arbitration agreement are as follows. There will be heightened awareness of potential involvement of the non-signatory. There will likely be incorporation of explicit inclusion or exclusion clauses in the arbitration agreement to restrict a potential impediment of a non-signatory to an arbitration arising out of an agreement. It is highly probable that a detailed and express documentation of mutual intent to impede the non-signatory is kept by the parties. Development of comprehensive contract management to clearly identify the roles of non-signatory to an agreement. There may be an increase or decrease in involvement of a non-signatory in the performance and execution of a contract executed by its signatory affiliate depending on the intention of the group companies. There may be strategic use of arbitration clauses in the agreements depending on the parties' intent to bring the non-signatory within the ambit of the arbitration agreement.